Indigenous intellectual property is an umbrella legal term used in national and international forums to identify indigenous peoples' rights to protect their specific cultural knowledge and intellectual property. It is a concept that has developed out of a predominantly Western legal tradition of intellectual property law, and has most recently been promoted by the World Intellectual Property Organization, as part of a more general United Nations push to see the diverse wealth of this world's indigenous, intangible cultural heritage better valued and better protected against perceived, ongoing thievery. Nation-states across the world have experienced difficulties reconciling local indigenous laws and cultural norms with a predominantly Western legal system, in many cases leaving indigenous peoples' individual and communal intellectual property rights largely unprotected. Therefore, international bodies such as the United Nations have become involved in the issue, making more specific declarations that intellectual property also includes cultural property such as historical sites, artifacts, designs, ceremonies, and performing arts in addition to artwork and literature. Declarations regarding indigenous intellectual property. While a number of Native American and First Nations communities have issued tribal declarations over the past 35 years, in the lead-up to and during the United Nations International Year for the World's Indigenous Peoples, then during the following United Nations Decade of the World's Indigenous Peoples, a number of conferences of both indigenous and non-indigenous specialists were held in different parts of the world, resulting in a number of unified declarations and statements identifying, explaining, refining, and defining indigenous intellectual property. United Nations Declaration on the Rights of Indigenous Peoples, September 2007 at the United Nations General Assembly's 61st session. On 13 September 2007, an overwhelming majority of members resolved to adopt the United Nations Declaration on the Rights of Indigenous Peoples, regarding the intellectual property rights of indigenous peoples. The General Assembly recognized the urgent need to respect and promote the inherent rights of indigenous peoples which derive from their political, economic and social structures and from their cultures, spiritual traditions, histories and philosophies, reaffirmed that indigenous peoples possess collective rights which are indispensable for their existence, well-being and integral development as peoples, and solemnly proclaimed as an agreed standard for member nations around the world. Article 11. Indigenous peoples have the right to practice and revitalize their cultural traditions and customs. This includes the right to maintain, protect and develop the past, present and future manifestations of their cultures, such as archaeological and historical sites, artifacts, designs, ceremonies, technologies and visual and performing arts and literature. States shall provide redress through effective mechanisms, which may include restitution, developed in conjunction with indigenous peoples, with respect to their cultural, intellectual, religious and spiritual property taken without their free, prior and informed consent or in violation of their laws, traditions and customs. Article 24. Indigenous peoples have the right to their traditional medicines and to maintain their health practices, including the conservation of their vital medicinal plants, animals and minerals. Article 31. Indigenous peoples have the right to maintain, control, protect and develop their cultural heritage, traditional knowledge and traditional cultural expressions, as well as the manifestations of their sciences, technologies and cultures, including human and genetic resources, seeds, medicines, knowledge of the properties of fauna and flora, oral traditions, literatures, designs, sports and traditional games and visual and performing arts. They also have the right to maintain, control, protect and develop their intellectual property over such cultural heritage, traditional knowledge, and traditional cultural expressions, in conjunction with indigenous peoples. States shall take effective measures to recognize and protect the exercise of these rights. Resolution of the 5th Annual Meeting of the Traditional Elders Circle, October 1980. Before ceremonies and ceremonial knowledge were affirmed as protected intellectual property by the UN General Assembly, smaller coalitions of indigenous cultural leaders met to issue declarations about protection of ceremonial knowledge. In 1980, spiritual leaders of the Northern Cheyenne, Navajo, Hopi, Muskogee, Chippewa Cree, Haudenosaunee and Lakota nations met on the Northern Cheyenne Reservation in Montana, and issued a resolution that these non-native individuals are gathering non-Indian people as followers who believe they are receiving instructions of the original people. We, the elders and our representatives sitting in council, give warning to these non-Indian followers that it is our understanding this is not a proper process, that the authority to carry these sacred objects is given by the people. Declaration of Belem, July 1988. The First International Congress of the International Society of Ethnobiology involving anthropologists, biologists, chemists, sociologists, and indigenous peoples met at Belem, Brazil. They identified themselves collectively as ethnobiologists, and announced that since indigenous cultures around the world are being disrupted and destroyed, mechanisms ought to be established by which indigenous specialists are recognized as proper authorities and are consulted in all programs affecting them, their resources and their environment. Procedures must be developed to compensate native peoples for the utilization of their knowledge and their biological resources. Currioca Declaration and Indigenous Peoples Earth Charter, May 1992. The Currioca Declaration and Charter was first affirmed in Brazil in May 1992, and then reaffirmed in Indonesia in June 2002. Ratifying the document were indigenous peoples from the Americas, Asia, Africa, Australia, Europe and the Pacific who, at Currioca villages, united in one voice to collectively express their serious concern at the way the world was exploiting the natural resources upon which indigenous peoples depend. Specific reference is made within the Indigenous Peoples Earth Charter to perceived abuses of indigenous peoples' intellectual and cultural properties. Under the heading, Culture, Science and Intellectual Property, amongst other matters, it is asserted, 99. The usurping of traditional medicines and knowledge from indigenous peoples should be considered a crime against peoples. 102. As creators and carriers of civilizations which have given and continue to share knowledge, experience, and values with humanity, we require that our right to intellectual and cultural properties be guaranteed and that mechanisms for each be in favor of our peoples. 104. The protection, norms and mechanism of artistic and artisan creation of our peoples must be established and implemented in order to avoid plunder, plagiarism, undue exposure, and use. Declaration of War Against Exploiters of Lakota Spirituality, June 1993 at the Lakota Summit v. an international gathering of U.S. and Canadian Lakota, Dakota and Nakota nations. About 500 representatives from 40 different tribes and bands of the Lakota unanimously passed a Declaration of War Against Exploiters of Lakota Spirituality. Representatives affirmed a zero-tolerance policy on the exploitation of Lakota, Dakota and Nakota ceremonial knowledge. Whereas we are conveners of an ongoing series of comprehensive forums on the abuse and exploitation of Lakota spirituality, and whereas we represent the recognized Lakota leaders, traditional elders, and grassroots advocates of the Lakota people, and whereas non-Indian charlatans and wannabes are selling books that promote systematic colonization of our Lakota spirituality, and whereas this exponential exploitation of our Lakota spiritual traditions requires that we take immediate action to defend our most precious Lakota spirituality from further contamination, desecration and abuse. 6. We urge traditional people, tribal leaders, and governing councils of all other Indian nations, as well as all national Indian organizations, to join us in calling for an immediate end to this rampant exploitation of our respective American Indian sacred traditions by issuing statements denouncing such abuse, for it is not the Lakota, Dakota and Nakota people alone whose spiritual practices are being systematically violated by non-Indians. 7. We urge all our Indian brothers and sisters to act decisively and boldly in our present campaign to end the destruction of our sacred traditions, keeping in mind that our highest duty as Indian people, to preserve the purity of our precious traditions for future generations, so that our children and our children's children will survive and prosper in the sacred manner intended for each of our respective peoples by our Creator. Matter 2. A Declaration on Cultural and Intellectual Property Rights of Indigenous Peoples, June, 1993. On the 18th of June 1993, 150 delegates from 14 countries, including Indigenous representatives from Japan, Australia, Cook Islands, Fiji, India, Panama, Peru, Philippines, Suriname, USA and Aotearoa met at Whakatane. The Assembly affirmed Indigenous peoples' knowledge is of benefit to all humanity, recognized Indigenous peoples are willing to offer their knowledge to all humanity provided their fundamental rights to define and control this knowledge is protected by the international community, insisted the first beneficiaries of Indigenous knowledge must be the direct Indigenous descendants of such knowledge, and declared all forms of exploitation of Indigenous knowledge must cease. Under Section 2 of their declaration they specifically asked state, national and international agencies to 2.1. Recognize that Indigenous peoples are the guardians of their customary knowledge and have the right to protect and control dissemination of that knowledge. 2.2. Recognize that Indigenous peoples also have the right to create new knowledge based on cultural tradition. 2.3. Except that the cultural and intellectual property rights of Indigenous peoples are vested with those who created them. Due Statement on Indigenous Intellectual Property Rights. November 1993. This declaration arose out of a meeting of Indigenous and non-Indigenous specialists, who, at Jingaba, in northeastern Australia, agreed Indigenous intellectual property rights are best determined from within the customary laws of the Indigenous groups themselves. Within the declaration, Indigenous customary laws are named Aboriginal Common Law S, and it is insisted these laws must be acknowledged and treated as equal to any other systems of law. Indigenous peoples and nations reaffirm their right to define for themselves their own intellectual property, acknowledging the uniqueness of their own particular heritage. Indigenous peoples and nations declare that we are willing to share our intellectual property with all humanity provided that our fundamental rights to define and control this property are recognized by the international community. Aboriginal intellectual property, within Aboriginal common law, is an inherent, inalienable right which cannot be terminated, extinguished, or taken. Any use of the intellectual property of Aboriginal nations and peoples may only be done in accordance with Aboriginal common law, and any unauthorized use is strictly prohibited. Santa Cruz de la Sierra Statement on Intellectual Property, September 1994. A regional meeting was held at Santa Cruz de la Sierra, Bolivia, where Indigenous peoples from the South Americas concerned about the way internationally prevailing intellectual property systems and regimes appeared to be favoring the appropriation of Indigenous peoples' knowledge and resources for commercial purposes. Agreed. For members of Indigenous peoples, knowledge and determination of the use of resources are collective and intergenerational. No individuals or communities, nor the government, can sell or transfer ownership of cultural resources which are the property of the people, and which each generation has an obligation to safeguard for the next. Work must be conducted on the design of a protection and recognition system which is in accordance with our own conception, and mechanisms must be developed which will prevent appropriation of our resources and knowledge. There must be appropriate mechanisms for maintaining and ensuring the right of Indigenous peoples to deny indiscriminate access to the cultural resources of our communities or peoples, and making it possible to contest patents or other exclusive rights to what is essentially indigenous. Tambunan Statement on the Protection and Conservation of Indigenous Knowledge, February 1995. Indigenous people of Asia met at Tambunan, Sabah, East Malaysia, to assert rights of self-determination, and to express concern about, and fear of, the threat unfamiliar, Western, intellectual property rights systems may pose to them. It was agreed, for the indigenous peoples of Asia, the intellectual property rights system is not only a very new concept but it is also very Western, WITH Western style, intellectual property rights. Alien laws will be devised to exploit the indigenous knowledge and cultural resources of the indigenous peoples. The Western intellectual property rights system and the appropriation of indigenous knowledge without the prior knowledge and consent of indigenous peoples evoke feelings of anger, or being cheated. Indigenous peoples are not benefiting from the intellectual property rights system. Indigenous knowledge and cultural resources are being eroded, exploited or appropriated by outsiders in the likes of transnational corporations, institutions, researchers, and scientists who are after profits and benefits gained. For indigenous peoples, life is a common property which cannot be owned, commercialized, and monopolized. Based on this worldview, indigenous peoples find it difficult to relate Western intellectual property rights to their daily lives. Suva Statement on Indigenous Peoples' Knowledge and Intellectual Property Rights, April 1995. Participants from the independent countries and non-autonomous colonized territories of the Pacific region met in Suva, Fiji to discuss internationally dominant intellectual property rights regimes, and at that meeting they resolved to support the Carioca, Mataatua, Juleable, Santa Cruz de la Sierra, and Tambunan initiatives. In particular, participants reaffirmed that imperialism is perpetuated through Western intellectual property rights systems. Declare, ed. Indigenous peoples are willing to share our knowledge with humanity provided we determine when, where and how it is used. At present, the international system does not recognize or respect our past, present and potential contribution. Seek repatriation of indigenous peoples' cultural resources already held in external collections, and seek compensation and royalties from commercial developments resulting from these resources. Encourage governments to protest against any general agreement on tariffs and trade provisions which facilitate the expropriation of indigenous peoples' knowledge and resources. 2. Instead, incorporate the concerns of indigenous peoples into legislation. Seek to strengthen the capacities of indigenous peoples to maintain their oral traditions, and encourage initiatives by indigenous peoples to record their knowledge according to their customary access procedures. Urge universities, churches, government, non-government organizations, and other institutions to reconsider their roles in the expropriation of indigenous peoples' knowledge and resources and to assist in their return to their rightful owners. Kimberley Declaration, August 2002. Indigenous people from around the world attended an International Indigenous Peoples Summit on Sustainable Development in Khoisan Territory, Kimberley, South Africa, where they reaffirmed previous declarations and statements, and, amongst other matters, declared, our traditional knowledge systems must be respected, promoted and protected, our collective intellectual property rights must be guaranteed and ensured. Our traditional knowledge is not in the public domain, it is collective, cultural and intellectual property protected under our customary law. Unauthorized use and misappropriation of traditional knowledge is theft.